Welcome to another episode of BHBA Family Law Presents Direct Examination with Dan and Lauren. Along with Lauren Youngman from Youngman Reitshtein, I'm Dan Bemel, financial advisor and certified divorce financial analyst. During each episode of our show, we'll explore our guest's personal and professional history and dig into some meaningful legal topics. We are very happy to announce our guest lineup through the end of the year and into 2022. With one exception, always the first Wednesday of every month at 12:30 p.m. Dana Lowy and Doreen Olson in August, Bob Brandt in September, Betty Nordwind in October, Joe Manis in November, Judge Elizabeth Scully in December, Christina Royce in January, that one will be on the 12th, and Larry Ginsburg in February. The links are already up on the bar's event calendar and will be posted in the chat box during today's program. Lauren.
Thanks, Dan. Good afternoon, everyone. You will receive your MCLE certificate shortly after the program. Please take a moment to complete the survey that's included with your certificate. The family law section is sponsored by White, Zuckerman, Warsofsky, Luna, and Hunt, and Our Family Wizard. White, Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Our Family Wizard is a secure co-parenting platform that supports divorced or separated parents in managing the daily responsibilities of raising children. Specialized features help co-parents organize routines, share files, track expenses and payments, check in at exchanges, send messages, and more, all while thoroughly documenting their activity. Thanks to our sponsors, and now let's begin the program. I'm going to throw it back to you, Dan.
All right, thanks, Lauren. So, as you all know, today we're talking with Judge Lawrence Riff, supervising judge of the Los Angeles County Superior Court Family Law Division. Judge Riff calls his path to the bench unusual, and we're going to explore that. In short, Midwesterner by upbringing, on to the University of Michigan, became a healthcare data analyst in Portland right out of school, before ultimately graduating from the University of Oregon School of Law. His first job out of law school was as an in-house counsel for the Southern Pacific Railroad in San Francisco as a civil jury trial lawyer, which led to a long career in private practice, culminating with a 2-decade run as the managing partner of Steptoe and Johnson's LA office and a member of the firm's executive committee. At that 600-plus attorney firm, he was also the national practice group leader for environmental and toxic tort litigation. So about 6 years ago, after 33 years of practice and taking more than 45 cases to jury verdicts in state and federal courts, he was appointed to the LA Superior Court. If that wasn't enough, here's where the plot really thickens. Up to that point, he had never set foot in a family law courtroom. And as we all know, today he's the supervising judge for the biggest family law division in the country, a role that he sees as, quote, being at the intersections between the aspirations of the judges, the needs of the family law community, and the operational realities of the court. We have so much we want to talk to Judge Riff today about, including unpacking that job description. But first, most importantly, thank you for joining us, Your Honor.
Well, thank you, Dan, Lauren. Thanks for inviting me. Listening to the lineup of folks coming down the pike, I feel like I'm in very fine company. So thanks for having me.
Surely, yes, of course. And let's get right into it. And I'll go out a little bit on a limb here and try something different from what we've done in the past. What can you share with us? Maybe break some news that you haven't spoken about publicly or broadcast very widely about things that are going on in the division today.
Oh, hadn't you heard? So the California legislature is doing away with no-fault divorce, and we're going back to the world of infidelity and mental cruelty on January 2. No, that's not true. That is not really what's happening. I think what I can tell you is not so much breaking news Everything I will be reporting today is probably below the fold on page 1, as they say. I think the news I want to share, big picture, is that, we are emerging from the biggest shock that certainly our court has ever experienced in the history of the state of California. And while it's customary for a guy like me in a setting like this to be very upbeat and traffic in happy talk, it is not mere happy talk when I tell you that our division truly exits the COVID era stronger than when we went in. We are doing things that we thought we could not do. We have learned lessons. We are applying the lessons we've learned. I think there is a broad sense of shared burden over the last 16 months among the 67 of us in this division. I think we share a sense of, what would be the right term? A sense of satisfaction that we rose to an unparalleled challenge. Now, it was a bumpy road, to be sure, and the road is still not smooth yet. But we are a group of judges and commissioners who are in high spirits. We are picking up where we left off in February of 2020. There are a bunch of things that we think we can do better for the community, for you all, for the families, and we are very committed to doing that. I hope I get a chance to tell you about some of the things that are coming down the pike. They are below the fold, but still front page news.
Well, let's start with that. How much of the total volume of court proceedings do you think are going to be coming back in person? Let's start there.
Depends what the metric is. If you, I don't want to go technical on you here, but are we talking about percentage of hearings or percentage of hours spent in court? Here's what I think. Neither we nor anybody else has figured out what the new workplace looks like, right? Everywhere you go, there is a lack of understanding about going back to the office and what that means. So too in the courts. The family law division is benefited in a sense as compared with civil and criminal because we can do our work without having to impanel a jury panel. And that makes a big difference. My belief is that remote hearings, which were, if not aberrational, at least unusual as of February of 2020, are no longer aberrational or unusual. They are usual. I think people love them. I think people recognize the limitations with respect to evidentiary proceedings. But Dan, my sense is that most of the more pedestrian or prosaic kinds of hearings, trial setting conferences, many RFOs who do not have a 217 hearing associated with them will be remote. Probably most trials and longer 217 hearings, not so much. But we'll wait and see. It's my best answer.
Okay, so is that to say that even though, as we were just discussing, a lot of people are starting to come back to court, that attorneys and parties can still utilize LA Court Connect and they can still do remote appearances for the time being without any special permission?
Yes, for the time being, the answer is yes. Under the current general orders of our presiding judge, we are still, frankly, encouraging remote appearances. There's a technical matter of law working its way through the legislature right now with respect to whether and how remote appearances will be authorized. It turns out that a lot of what we're doing, not only in this court, but in all courts, is authorized under current emergency orders promulgated by the Judicial Council that are still in effect. And we don't know what's going to happen when those emergency orders terminate, nor do we know when they're going to terminate. It's my belief, at least, that there's a lot of appetite in the legislature to continue to authorize remote hearings. So that's my bet, Lauren.
Okay. And where are we with filing? Is there any news about that? I know that at least in our division here in Los Angeles, we're now able to email in ex parte applications, and I know fax filing has been expanded. Is there any other news about changes with filing coming to the division?
Yes, I think this is a below the fold front page piece of news. I believe that our court has recommitted itself to e-filing in family law. And I know a lot of folks on this call have heard it before, and I know that there's a risk of crying wolf. But I have firsthand knowledge from firsthand conversations with our CEO and others in the front office that they know that we need e-filing. They know that you need e-filing. Now, we still suffer from some of the same problems that scuttled e-filing 2.5 years ago with respect to software. Those problems have not yet been solved. And I'm not going to spin off into the details of that. I'm going to tell you this. I genuinely believe that by the end of 2022, we will have fully operational e-filing in our division. There is a question whether we will have partial e-filing capabilities in the division before the end of 2021. But
I'm going to count that
let me just say, excuse me for interrupting.
No.
Let me just say, it's going to revolutionize the practice. It's going to revolutionize the culture. A lot of things that we're doing today are really based on 1995 technology. We're doing our best, but I really think it's going to be the most fundamental change in family law, probably in decades. So I'm pretty excited about it. I'll tell you this, again, one more thing. I don't know if you know this, every Wednesday, we have what we call a team meetings. It's an operations meeting. It consists of the director of the department who reports to Denny Butler, who reports to Sherry Carter. Her name is Anna Ruth Gonzalez. And 2 or 3 of the folks that report to her on the operations side. It consists of Susan Thrall, who is the head of Family Court Services, me, and our 2 assistant supervising judges, Judges Kaufman and Pellman. Every Wednesday, we meet, and it's basically an operations meeting. When I say that this job is at the intersection of the hopes and aspirations of the court, of the judges and the operational realities of the court, that's where the rubber meets the road. We have a standing agenda item every week. Item 1 is e-filing status update, and it's taking a lot of energy right now. So I'm pretty excited about it.
All I was going to say is I'm going to count that as above the fold breaking news, e-filing by the end of 2022. So and I want to come back to the overall trajectory of the division. But first, I want to talk a little bit about your personal trajectory. And I went through I gave some of the highlights in the intro, but in your telling, how did a toxic tort litigator with no family law experience end up in the chair in one of the most demanding divisions in the country?
Well, I've wondered that myself, not surprisingly. And my view of that, Dan, is that the institution hired from the outside, as they say. In organizations, you could divide the world into 2 categories. When a chief job is filled by somebody who comes through the ranks versus hiring from the outside. There are pros and cons to each of those things. One of the pros of hiring from the outside, as it were, is you get a person, in theory, who is not wedded to cultural ways of doing things, not wedded to historical events. But part of the downside of hiring from the outside is the person is not particularly steeped in the culture of the institution. And often it's the culture, it's the glue that holds the thing together. So I have to tell you that the reason I'm in this chair, in my opinion, is because of the confidence that Tom Lewis and Dan Buckley had in me. And it sort of went like this. I haven't really told the story, and if you want me to, I can, how I ended up in a family law court to begin with. But as noted, I spent 35 years in law, never stepping foot in a family law court. I've been married to the same person for 30 years and I have no kids. So I'm a natural for family law, right? But I wanted to go to family law. There's a reason why, and I did. And when Hank Goldberg retired, for reasons known to Tom Lewis, he asked if I would, basically asked Dan Buckley, the then presiding judge, if it would be okay for me to help him as the assistant supervising judge. Now, I know something about organizational activity. As you noted, I was the managing partner of a pretty busy office of an international firm for 2 decades. I was a practice group leader. I've been on a bunch of other committees. So the idea of how organizations work was not foreign to me. So when Judge Buckley asked if I would serve in that capacity, of course I said yes. He would not ask if if that was his ask, and the answer was yes. Less clear to me, to be honest with you, is whether I would be asked to take over as supervising judge when Judge Lewis retired. And that was Judge Brazil's call. And I didn't know what would happen. There's a long tradition in the Superior Court. Sometimes ASJs become SJs and sometimes they don't. To be honest with you, it's a different skill set. It's a different skill set. Judge Brazil, frankly, in my view, he took a risk on me, and he asked and I said yes. That was roughly 2 years ago. And I think I've grown into the job. I'd like to think I've grown into the job. That's how it happened, Dan. I'll tell you one just last thing on this. I do think I'm actually pretty good at the job when it comes to things like, as I say, dealing with that intersection between the aspirations of the court, the needs of the community, and the operational realities of the court. Court operations is its own thing. And as a lawyer, you don't know anything about it or not much. And as a judge, most of us don't know anything about it. But here's what's funny to me. I think a lot of people think because I'm sitting in Department 2, I'm actually an expert on family law, which I'm not. I know enough family law. I've been doing it for 4 years and I'm not a slouch, but people call me thinking that Tom Lewis is going to pick up the phone. And I'm here to tell you, I don't know as much family law as Tom Lewis. But
you do.
But I'm doing okay. I'd like to think.
And so when you started out in the family law division, how do you think you were received both by the division and by the bar?
Well, I think by the bar, I was received with Well, bafflement might be too strong a word, but I think a lot of folks in the bar were of the view, who is this guy and why is he in that chair? I think among my colleagues on the bench, at that point, I pretty much knew everybody, although I didn't know everybody well. I'd been in a home court, I'd been in a dedicated trial court. And I think there were plenty of people, plenty of our judicial officers who asked the same question. Why is Riff in that chair? What does he know about family law? And look, there may be people to this day that are of that view. Hard to say. So I would like to think, I'll just finish.
Yeah.
People are very nice to you when you're the supervising judge, I will tell you. Certainly publicly, they're very nice to you. And the bar over the last 2 years has been really nice to me, very warm, very accommodating, I think very forgiving of some of my novice moves. I hope by now I've established some bona fides with the bar that even if I don't know everything that is in the Rudder Guide, I still am capable of the operational aspects of being the supervising judge. Within the bench, I feel that Judge Kaufman, Judge Pellman, and I have a lot of support. We're blessed by the support that we have.
On the law itself, I can only imagine when a long tenured practitioner says something kind of what you alluded to in a self-deprecating way. Let me explain how Judge Lewis or Judge Black would rule, or in my 40 years, I've never seen, you've only been here for 4. What do you think? What do you do?
Well, it comes up all the time. It used to come up more.
That's progress. That's good.
Dan, it would sound something like this. And the lawyer would try not to be patronizing, but of course, how can you not be patronizing in that situation? Yeah. It's like, well, Judge Riff, I really appreciate that you've read everything, and I'm sure you're very well prepared, but I know that you're new to family law, and I would like you to know that I've been doing this for 40 years, and I'd like you to know, how Judge Black used to handle this, and how Judge Lax used to handle this, and how Judge Rothschild used to handle this. And Tom Lewis, for God's sake, this is what he would do in your situation. And I was never offended by that, Dan, I'm really not offended. It's just not helpful, I will tell you. It's not helpful. What I did and what I do in my training of new judicial officers coming into the division is I encourage them to ask the lawyers to educate us, right? We don't know everything, and they know we don't know everything. So, counsel, I understand what you want, but can you cite me to a statute, a rule, or a case that permits me to do what you want? And if the answer is, well, Judge Black did that all the time, then my view is there's probably not any authority for that. So I don't find it a helpful piece of oral advocacy as to what other experienced supervising judges used to do.
That's good advice for really any presentation. You should know your authority for asking for what you want. I've heard you describe your role as one of an air traffic controller. And outside of air traffic control, when we're sent down to Department 2 for being set for trial, you sometimes hear cases. How do cases get assigned to you for actually being heard on the merits?
All right, great question. Thank you for that. By the way, for everybody's benefit, we did not rehearse questions and answers here. So even though I had some vague sense of what might be coming, these are all These are all candid questions. So I want to answer the question, but I want to give you a little background on it. In my opinion, where the action is in the family law division is in the home courts, okay? That's where the rubber meets the road. And by home courts, I mean the family law home courts and the AB 1058 home courts. In a sense, they are what the civil division calls an IC court, independent calendaring. A case is assigned to that judge, and from cradle to grave, that's where that case lives. And I define everything that we do operationally in our court as empowering the home court judges and commissioners, because that's where the cases are. That's where we have to move the cases. That's where justice is dispensed. In order to empower the home court judicial officers, we need to have some other things in the division. We need to have trial courts, because the home courts really can't handle long 217 evidentiary hearings and trials. Now, I do want you to know that we strongly encourage our home courts to keep any evidentiary hearing or trial that they want. If it's a 14-day trial and they want to keep it, fine with us, okay? If there ever was a rule, and I think there was, that some trials or some things had to go to Department 2 for reassignment, that is no longer the rule. Any home court can keep anything the home court wishes to keep. Okay. Another thing we need in order to empower the home courts are settlement courts. Another thing we need to empower the home courts, in my opinion, are standalone restraining order courts. So over the past 2 years, we have reinstituted standalone restraining order courts. We've we've expanded the number of settlement courts from 1 to 3, and we're at least 1 short of where we need to be, in my opinion. And we have trial courts, and we had at one point 9, we're now down to 7. And in a moment or two, if you ask me the right question, I'll tell you about the zero-sum game aspect of running a division in this court. Okay, now, one of the things I changed when I came into Department 2 was Department 2's role relative to our dedicated trial courts. What was the former practice before I became the supervising judge was Department 2, in essence, ran the calendars for the dedicated trial courts, or what was then called long cause departments. So when a matter was sent to Department 2 for assignment to long cause, the litigants would walk out with a date. This is your date for trial. This is your department. We changed that. And we changed it because, in my opinion, it is more efficient for the dedicated trial court judges to run their own calendar. And briefly, here's why. So if somebody showed up in the former days and said, I need 5 days, and we concluded, yes, you do, you need 5 days, we looked for a block of 5 days rather than a day here, a day here, a day here, and a day here, because we couldn't do that at the level of detail. But Judge Uhas, Judge Byrd, Judge Iwasaki can do that. They know their calendar well enough that if we say, okay, you're assigned to Judge Iwasaki, go there now, or go call his department now and get on his calendar, he might be able to piece together with your calendar 3 or 4 days and get your trial done sooner than later. So that's why we made the change. There's a correlate to that, and now I'm finally getting to your question, Lauren. That means the air traffic control job in Department 2 is considerably less onerous than it used to be. I mean, now my job is Are you really ready? How long is it really going to take? And am I ready to assign you to a judge? And if so, okay, goodbye. Go talk to that judge. I'm not going to worry about calendaring your trial. That has opened more time on my calendar. The other thing I want to tell you, Lauren, is I did not become a judge. I didn't seek the appointment in order to be an administrator. I mean, I did that for 20 plus years as a managing partner. I liked it, but I wanted something different when I hit the bench. So what I wanted to see is, could I be a supervising judge and also hear family law matters? And the answer is yes. I consider Department 2 to be about a 0.6 full-time equivalent trial court. And so I assign cases to myself along in the rotation with everybody else. I put people in the awkward position of having to exercise a 170.6 to my face. But, lawyers need to have courage. And, like they said in The Godfather, it's not personal, it's only business. So that's how things get assigned to me.
Let's dig in a little bit more on the actual process and the way the cases are moving through the system right now. You've spoken a lot in the past about your vision for what you call muscular case management. Where are we at in that? I know COVID kind of changed the game a little bit, but as you mentioned in your open, we're kind of coming out of the crisis stronger as a division. So where are we at in muscular case management, setting trial dates, reducing the number of touches on the file, and moving cases more purposefully through the system, as you've also said in the past?
Okay, so muscular case management, my term, some people object to that. They think muscular is an unpleasant word. So let's just say directed case management. I just want to say, it's not an end in itself. It's a means to an end. And what is the end, you might say? I mean, what's the problem we're trying to fix with more case management? The problem we're trying to fix, in my opinion, is twofold. One is that we have very substantial turnover of judicial officers in the division. That's a bad thing for the community. It's a bad thing for the court. I've spoken about this over the years, and I'll just hit the highlight again today. Why do we have substantial turnover among our judicial officers, and why is it a bad thing? Well, it's a bad thing because it takes a while to get a feel for family law. Not only the community, but the law, the culture, and I think everybody would agree, a judicial officer 30 months into the job is probably more comfortable than somebody 3 months into the job. And I think you are more comfortable appearing before such a judicial officer. So it's bad if we are frequently turning over judicial officers. Why are they leaving? Well, for some people, it's just not their cup of tea. It is a high stress, high emotion environment. But I contend that for a lot of folks, they become burnt out. They become burnt out because the workload is crushing, and because often there is a sense that there is not progress being made for many families. And people say, I think I should be doing something else. Okay. The other reason, the other end in sight is it is a good thing for families to bring to closure their family law litigation. I mean, it's self-evident, right? You don't have to be on the Elkins task force to know that that's a good thing. And We are only so good at that, in my opinion. We are not bringing matters to conclusion as quickly as we can. As a result of that, there is tremendous emotional wear and tear on the families, on the litigants themselves. There's tremendous expense that is going to litigation rather than things like college education. And it doesn't have to be like that, in my opinion. The way we can change that, in my opinion, is by case management. Now, where am I coming from? Why do I think that? Well, I was a practitioner for 30 years in the federal and state courts throughout the country, where the civil divisions had pretty directed case management. Now, we are not the Southern District of New York. The Family Law Division does not aspire to be the Southern District of New York, and our work is not a 100-count RICO criminal matter, with the Department of Justice on the other side. So we're not looking to reproduce that. But between that and a notion that we are a court of equity where pretty much anything goes because we're doing it for the children, which is often what we hear, I am saying that we can enhance everybody's experience by more case management. Now, you ask, how is it going? I would say B-. I give us a B-, and you're completely right about COVID. When COVID swept over us like a tidal wave, the answer was yes to pretty much any question anybody had, like, can I get a continuance? Is it okay with you if I don't do this now? The answer was yes, yes, yes. And we still need to have a pretty liberal point of view on those things because we are not out of COVID. But there are things we can and need to do. So, for example, when Judge Lewis was in this chair, he and I worked on a series of supervising judges' orders requiring people to do things that people don't do. And by and large, our culture in the division has been rarely to enforce those orders. Now, I think we should change that. I don't personally understand. Now, let me just say, I've never practiced family law. I was a lawyer. I've had clients. I understand how those things work. But when there's a statute that says, thou shalt serve a preliminary declaration of disclosure within 60 days, it is foreign to my nature for a lawyer to say, I'm not going to do it. I don't understand that, to be honest with you. And that is something we see very often. When there is a supervising judge's order and a California rule of court, 5.98, that says, thou shalt meet and confer on the subject of an RFO before the hearing, and the lawyers don't, that's foreign to my experience. I don't understand that. Now, I've learned that for whatever reason, we have tolerated that. Many of you don't want us to tolerate that. And many of you have asked that we not tolerate it, that we, be directing / muscular. I think those are things that we need to work on. Now, I will tell you what breaks my heart. Sitting in Department 2 every day. Breaks my heart is too strong a word. I am disappointed by, maybe a little crestfallen. This is the case I see 3 times a day in Department 2, okay? It's a dissolution case, 13-year marriage, 2 school-age kids, represented by perfectly good, I mean, very good, often, family law lawyers. The case is 3.5 years old. The family has a house and maybe $250,000 in other things like retirement accounts. And now the case is 3.5 years old. They've each expended $70,000 on temporary orders. The home court has thrown up its hands and said, I deem you ready for trial. And I see them, and it's 3.5 years later, and I say, are you ready? And the answer is no, we're not ready. We need to do this. We need an appraisal for the house. We need A, B, C, and D. I am disappointed by that. And I can see it in the eyes of the litigants. They're disappointed by it. It's like, when is this going to end? How much more is this going to cost? So one thing we are probably going to do that I don't think some people in the community are going to will like, is the following. I plan to set a trial date in your dissolution, nullity, and legal separation case upon the filing of a response. You're going to get an automatic trial date in your home court.
What's that going to look like?
Well, I'll
like
tell
a
you
minute order, or just like your case assignment?
It's going to look like this is your trial date. You're going to get a trial readiness conference X number of days in advance, probably somewhere between 80 and 110. There's going to be an order of things that need to be done for the trial readiness conference. And at the trial readiness conference, the home court, which I again emphasize it is my goal to empower, not to limit, but to empower, that home court judicial officer can do anything he or she wants. Advance the trial, continue the trial, send you to Department 2 at that point. But at that point, you have had a discovery cutoff for probably 2 years. You know when things are due. And, I didn't get around to serving my PDD or my FDD isn't going to cut it. And I plan to do it. And I'm drawing from my experience in the civil world. Now we'll see what happens.
When can we expect that to start?
I hope in early January. Let me tell you something about the LA Superior Court. It is a monster in the sense how big it is,
right,
and how complicated it is. You can't do something like that relative to court operations with the tens of thousands of filings per year, 12 courthouses, without court operations having everything just so in advance. So that's how it's going with case management. Now, let me tell you, I am not focusing on parentage cases. I'm not focusing on self-represented litigants. I'm not focusing on AB 1058 cases. I'm focusing on dissolution matters where parties are represented. Okay?
Okay.
You mentioned in one of your earlier responses about turnover and how these two issues are linked, moving cases through the system and retaining talented bench officers. How does that work from your chair? Do you recruit from other divisions? Do you try and convince judges who are in the division to stay? Or is the process more hands-off? I think that's a little opaque sometimes.
For good reason, because it is an opaque process. So I surely, not only I, Judges Pellman and Kaufman and I definitely implore judicial officers in the division to stay. And we often ask them, what can we do to entice you to stay? But I want to note that a lot of the folks who join us, it is their first assignment, and they have a long judicial career ahead of them. If they want to taste the fruits of other trees, it's fine with me. We have some great judges right now. I know they want to go to criminal. I know they want to go to civil. I support them. If that's what they want to do, I want them to go. I don't want them to go because they can't take the heavy load of family law. The family law judges who say, I love the assignment, but it's killing me. Those are the ones, I'm imploring to stay with changes to our operations. Now, recruiting, this is just a Judge Riff thing. There are 5 divisions of our court. Each division has a supervising judge, and those supervising judges are my friends and my colleagues. I talk to them all day long. We have a lot in common. We have to get along, and we do get along, and it really is a one court thing. And I will not recruit a judicial officer from another division because without having communicated in advance to my colleague, another supervising judge, hey, I think so-and-so might be a good candidate. Are you okay with my approaching so-and-so about coming to family? All right. So that's how the recruiting goes. At least from my perspective, there's nothing more than that happens. Sometimes the answer is, of course, thank you for the heads up. As long as we can get coverage, it's fine with me. Sometimes the answer is, well, I'd like you to hold off, and there's a reason, and here's why, and it's something I didn't know about. With respect to new appointments, that is with the presiding judge. The presiding judge knows what he's doing. We have a friend in Eric Taylor, in my opinion, as the presiding judge, the family law division. He's interested in family law. He asks good questions. He requires accountability. He does all the things that a good boss does, and I know he supports our division. So when he can assign incoming judicial officers to family law, I know he will. But no, I do not lobby him per se. I might drop a note and say, oh, I see so-and-so. I see Elizabeth Scully just was appointed. Just in case you didn't know, she's a certified family law specialist. Maybe you ought to consider her for family law, but it's never more than that because it's his call entirely.
Well, and this topic actually made me think of something that you briefly mentioned earlier, that you think we have one too few settlement courts right now in the family law division. What's the status on that? Will there be another assignment to the settlement court? And a related question is, what is the status of referring cases to ISCs and settlement conferences? I know that I've heard anecdotally from some judicial officers that too many people are requesting voluntary settlement conferences and they're not quite ready for settlement, and that I've been rejected sometimes asking now when it was freewheeling before.
Well, it's a big question. I'm looking at the time. This is what, a 3-hour thing we're doing today?
We'll have to have you back for a follow-up.
Yeah. Thank you for that. So I'm going to try to keep this short. The truth is that of course, the vast majority of family law matters that are contested eventually settle, right? And the question is how to advance that in terms of time. And it's a conundrum. In the Superior Court, it's large, how do I say this? I would love, and I think Judge Taylor would love, for family law to have 6 to 10 more judicial officers, and we sure could use them. And if we did that, we would probably have 2 more settlement departments. We are not going to be getting more, 6 to 10 more bodies. It is largely a zero-sum game. We currently have something like 18 vacancies. We frequently have 18 vacancies on our court. We're waiting for appointments. The criminal division has its needs. Mental health has its needs. And I think by and large, we need to do what we're going to do with our division with the body count that we have. Okay, that's our planning. If we have another settlement court, we have to close something. I elected to do that by opening Judge Roberts' settlement court in Van Nuys by essentially closing a dedicated trial court. I would like to have another settlement court. It's like number 3 in my priority of things we need by way of additional departments. We've also tried, Lauren, to demystify the settlement conference process. And here there are just too many words, too many adjectives chasing too few nouns or something. We now have 2 kinds of settlement conferences. We have something called a mandatory settlement conference and an informal settlement conference. That's all there are. We used to have an animal called a voluntary settlement conference, which was something pretty much reserved for complex cases. Department 2 needed to approve it. There was a questionnaire that needed to be filled out. That program is currently in hibernation. With respect, and it is true, yes, it is true that we don't have the capacity in our 3 settlement courts for the demand for all the MSCs and ISCs that everybody wants. Right now, we're setting MSCs in mid-November, and I can get people out to trial well before that. So that's an issue, right? Judge Kaufman really is running the show on this for good reason, and I'll just leave it with this. We plan to allocate settlement conferences, basically 70% MSCs, 30% ISCs. We are asking our home courts to be more discriminating about ISCs. We really want people to be ready to have a meaningful settlement conference. So yes, we are rationing ISCs.
So I think this will be the last one for me. You mentioned it, and we've talked a lot today about what's going on the bench side of things. A developing theme on our show through the episodes so far has been meet and confer and kind of the lack of follow through in that process. Beyond that, beyond the kick needed there, what other things can practitioners do to help the court, help buy into the vision that you're describing and deliver the resolutions to the families that everybody wants?
Dan, I wish I knew the answer to that. You know, I don't think a regime of terror is the way to do it, you know, through heavy sanction and 271 motion practice. As I say, we are not the United States District Court for the Southern District of Manhattan. But it does disappoint us very much. Look, lawyers occupy a privileged place in our society. We give them licenses to do really important things, and lawyers have 3 roles. They're zealous advocates, they're warriors for their clients. They're wise counselors behind a closed door. And there's a 3rd hat, they're peacemakers. They should be peacemakers. And that is the muscle that I think is underdeveloped in our culture. And it's not just meet and confer, it is resolution of issues and matters for trial. I don't know how to spur that muscle to greater growth. We have the tools of orders to show cause and sanctions. We can implore, which we do at every meeting like this, every judge's night. Every judge says, please, please, please meet and confer. And you can tell that it's a cultural failing in our community. So I would love to hear from you all what we can do to solve that problem.
Well, that would take probably a whole other program.
And a different panel, maybe.
Yeah. There was one more topic that we had discussed previously and almost forgot to bring up. So it'll be our last item for today. You had mentioned to us Family Code Section 6306 and the changes that have been happening to implement it in the division. Can you talk about that a little bit before we go?
I can. I'm glad you did. I think this is also a below the fold front page piece of news. Family Code Section 6306 is a statute found in the DVPA, and it requires that a criminal history be performed by the court following a hearing and before custody orders are made. For as long as I've been in family law, which, as noted, is not that long, our court, by and large, has not implemented 6306. It's our view, has been our view, that those data are not readily available to the court. And with, as I understand it, the blessings of the Judicial Council, by and large, we have not done that. Well, something I have wanted to change, and with the support of our presiding judge, for which I am very grateful, and the support of our CEO, Sherry Carter, for which I'm very grateful, we are going to be implementing Family Code 6306 shortly. It's a big deal. We are going to be using the CLETS database rather than DDES and some other things. We think CLETS is the correct one to use, or the best one to use. We need licensing from the Department of Justice in order to do it. We need training of JAs. We need to create 12,000 reports per year. We need a script for our judicial officers who need to say and do certain things under 6306. So all those things are in development. We are rolling out a pilot program in Pomona and Torrance, I believe on August 1, with a full division rollout in early January. I think it is one of the most exciting things we're doing. I think it's in the public interest, and I'm really delighted to be able to tell you about it. So thank you for not forgetting that. I appreciate it.
Yeah, it's big news, and it'll certainly have a big impact on restraining order practice, certainly.
And even if it's below the fold, I thought we did a pretty good job of some new stuff here for everybody.
Right. Well, we're perfect timing. It's 1:30. So as it became clear, I think we're going to have you as a recurring guest and come back again and fill in the community on more news.
I'm delighted to have been invited. Thank you so much. Invite me back someday. I'll be glad to come back. Goodbye, everyone.
Thank you. And just one final announcement while everyone's signing off. Please mark your calendars for our next episodes. They're all at 12:30 p.m. the first Wednesday of the month. Dan went through the whole list, so I won't repeat it, but registration links are posted on the BHVA calendar, and I believe they're in the chat right now as well. Thank you to Genna and Alex at the bar, the Family Law Executive Committee, currently led by Carrie Holmes and Ron Reitshtein, and of course, all of our section sponsors. And one last time, most importantly, thank you, Judge Riff, for sharing so much with us and for your time. We hope that you have a great rest of the week.
Bye-bye.